May it please the court. My name is Jason Azarone, and I am here on behalf of the appellants, Dr. Turnbull and Diagnostic Clinical Medical Group. I would like to reserve 5 minutes for rebuttal. Sure. Thank you very much. Your Honors, this appeal could have been negated with a simple phone call. A phone call from plaintiff's trial counsel to defendant's trial counsel advising him that he had met with a treating physician, showing him additional records, and that the testimony that he was going to provide at trial was different from his deposition testimony. One of the cases that I cited in my brief, Office Depot versus Miller, I'd like to just recite a little bit of that. And this is from footnote 2. The trial judge, however, found that appellant counsels waited until shortly before trial to ask Flatten, who was the physician, to reconsider documents he knew Flatten had in his possession all along in an effort to catch Miller by surprise at trial. There's no clear proof in the record to support the conclusion that the attorney was acting in bad faith. However, because of our agreement with the trial court's conclusion that Binger and Rule 1.360B required disclosure of Flatten's reversal of opinion, such a conclusion is unnecessary. What was blatantly unacceptable was the failure to inform defense counsel of the change. Your Honor, when I was in law school, I took a class and one of my instructors said, all 2 cases are always alike and all 2 cases are never alike. What occurred in Office Depot versus Miller, exactly what happened in this case. We have a situation.
Look at the deposition testimony and the trial testimony. They don't seem all that different.
And Your Honor, that's why I wanted to bring that up initially. What we have to look at is what did Dr. Rich testify to? At both fora, he testified that the ball started rolling with the administration of the morphine. That is clear in the record. However, if you look at his deposition testimony, what he says at, they'll point this out from the record. Record page 1061, the question was asked, if he is given morphine and suffers the encephalopathy, which is the confusion, these symptoms improve and then the encephalopathy reappears. Do you think the initial dose of morphine did anything to cause that encephalopathy? And at deposition, he said no. The morphine, and this is quoting him again, record 1061, the morphine, I don't see how it could have caused the symptoms once he improved and then got worse again if he only received 1 dose 3 days prior to me seeing him. That was not his testimony at trial. At trial, he attributed everything to the morphine. He attributed all the encephalopathy and everything. Basically, what he did was he fortified Dr. Fisher's opinion. If you remember from Dr. Fisher's deposition, what he likened this case to was the egg that cracks and it can't be uncracked. Once that crack starts, everything stems from that initial crack. So in this case, we have Dr. Rick, who is a treating physician who saw the decedent on 2 or 3 occasions at the hospital, didn't review any records by his own testimony, very rarely or briefly reviewed the nurse's notes, never put morphine in any of his records because he was looking for something else. In fact, in his deposition testimony, Your Honor, Dr. Rick testified that Ativan, in addition to all of the other medications and everything else going on at that hospitalization, would have contributed to the encephalopathy. But at trial, he testifies, no, Ativan's given to break that cycle. That's another clear distinction. Why is he making these distinctions? One simple reason. He was shown records 1 week prior to trial that he had never seen before. And this is by his own admission again. He testified at trial that he had not reviewed the nurse's notes in as great a detail prior to his deposition. In fact, he testified that he didn't even look at any records until his deposition, where he only looked at his office chart and his handwritten notes, and didn't look in as much detail at the records. So when did he do that? He did that 1 week prior to trial when he met with counsel. Meets with counsel. We don't know what happened at that meeting. We don't know. All we know is that he was shown records. He was actually shown the entire chart. Now, my office, the trial attorneys, have that in, I believe, 2 or 3 large binders of records. And Dr. Richt at trial testified with respect to what was contained in those records. So again, Your Honor, what happens? Trial counsel is preparing for an examination of someone he believes supports his causation defense. He believes is going to testify just like he did at deposition, that yeah, morphine got the ball rolling, but if there was a clear cut in that encephalopathy, I don't see how the morphine could have caused the ultimate death. And that's not what happened at trial. And counsel was caught completely by surprise, and this is the classic textbook example of an ambush. That's what this is here. Now, why is it important? It's important because defense counsel based their entire defense strategy on the testimony of Dr. Richt. Dr. Richt was a causation witness. He was a treating physician. The plaintiffs
He wasn't an expert witness.
No, he was not, Your Honor. I mean, there's the question there as far as whether a treating physician is an expert, quote unquote, for purposes of disclosure in witness lists or not. But the case law that I've read does say that their testimony is to be taken akin to expert testimony. He was permitted to come in and testify on the issue of causation. We don't contest that. However, when preparing this case for trial, you look at what we have. We have Dr. Fisher, who is a retained, paid expert by the plaintiff, who's going to do a records review. You have a treating physician. The treating physician comes in and supports exactly what the defense is saying all along. It couldn't have been the morphine. The encephalopathy symptoms were gone and then reappeared. So you have a treating physician who we know, according to the case law, juries tend to believe more than an expert. But we still have a battle of inexperts, so what does the defense need? The defense needs someone who's going to fortify what Dr. Rich said in deposition. We retain a pharmacologist. The pharmacologist is going to come up and basically support what Dr. Rich says in his deposition testimony. That all got blown out of the water when Dr. Rich got up at trial and testified, nope, it was all the morphine. In the brief, in the answer brief, counsel makes an attempt to say that there was no change, based specifically on that one point of this was, it all started with the morphine, got the ball rolling. That was there. We concede that. But what the appellees do not concede is the fact that Dr. Rich recognized that if those symptoms had stopped, what ultimately occurred could not have been caused by the morphine administration.
Well, there was never testimony that the symptoms stopped, was there?
There was, I believe
there was testimony that he got better.
Yes, and that's where we go again.
Improved.
Yes,
But
he improved.
He never returned to his baseline.
You're correct, Your Honor. He improved, which, according to what we saw in the deposition, would imply that the encephalopathy had dissipated. It had cleared up. The morphine was only in his system.
Well, now you're saying cleared up. You know, he never reached back to his baseline. He improved. It didn't clear up or go away.
Well, we don't know that, Your Honor. We know that.
What I'm saying is that wasn't the testimony. That it went away. It's just that he improved.
That was his testimony. However, he testified at deposition that if it had, and again I read, if the symptoms improve, could it have been caused by the morphine?
Right.
And the answer was no. That was his deposition testimony, no. Yet he comes into trial, and why does he come into trial and make this? Well, I looked at the nurse's notes in a little more detail. I didn't do that at deposition. I didn't have them at my deposition. They weren't there. When did you get them? A week before trial. What else did you look at? I looked at the entire chart. This is an ambush, plain and simple. That's what it is, Your Honor. We have defense strategy that is being predicated on what someone is going to testify to. Now, another thing that counsel in the answer brief points to is, well, there was no attempt at impeachment. Well, again, I think the Miller case and all the cases cited in my brief stand for the proposition that when you are blindsided, it's very difficult to impeach. It's very difficult to be able to ask questions. And there's a careful balance there at trial. You don't want to allow the expert to come back and continue to testify in the change, to make those changed opinions again and refortify them. But at the same time, you have to do something. And I think the record plainly shows that Mr. LaCava, trial counsel for the defendants, did all that he could in order to attempt to impeach him. But as the Miller court said, sometimes impeachment just is not possible. Sometimes you do not have the time to react. You don't have the time to prepare for something you did not know was coming. I think it's also important to point out that it's reasonable in this case to assume that had the phone call been made, had counsel contacted defense counsel, things could have happened that could have cleared up or negated the prejudice. Defense could have asked for a continuance of the trial. We could have asked for another deposition of Dr. Richt. We could have determined whether another expert was necessary for trial. All of that was negated. We did not have the opportunity to do that. It was also clear, Your Honors, that Dr. Rich's change in testimony absolutely came from this meeting he had with counsel. I counted at least 3 times where he testified that he was basing his testimony on the records he reviewed 1 week prior. He was basing it on the more thorough review that he had. And in closing arguments, Your Honor, plaintiff's counsel really hit this home, and that's really what shows the prejudice. On at least 3 occasions in closing, he argued to the jury, you only heard from 2 doctors, you only heard from 2 neurologists. That was his argument. Those 2 neurologists both testified that the morphine was the cause of everything that happened. So plaintiff's counsel, as he argued in closing, it was his job to tilt the scales of justice to his client's favor. He did exactly that. He ensured that that was going to happen by having this meeting with the plaintiff's Dr. Rick, his treating physician, and it resulted in a very large verdict, $2.25 million. Fairness dictates that this case be remanded for a new trial, and that is what we are asking for, Your Honors. Thank you very much.
Mr. Azzaro.
Oh, I'm sorry. I will be relying on, with respect to issue 2, Your Honors, I'll be relying on what was briefed. Thank you.
May it please the court. I'm Brandon Vesley from the law firm of Keene, Reese, Vesley, and Gertis. I'm here today on behalf of the estate of David Gabrielli and his personal representative, Marie Gabrielli. Your Honor, appellant argues he was ambushed by the trial testimony of Dr. Rich that was a complete reversal of his deposition testimony. Well, why then was there no record of impeachment at trial through the use of Dr. Ritchie's deposition testimony? The reason, of course, is there was no significant change in Dr. Ritchie's testimony. If you look at the briefs, counsel's been focusing the entire time on whether morphine was the cause of the problem, and today he comes in and says, I stipulate that was actually the same in the deposition and also at trial. So he's now kind of moved the ball again and said, okay, well, it's not so much the fact that morphine started the ball rolling, it's that there's some evidence that Mr. Gabrielli got better, and Dr. Rich would have testified that, according to his deposition, that it was not the morphine that caused him to decline after that. That question was never asked at court. They had the opportunity to do that. They made a motion to strike. They didn't move for a mistrial, but they made a motion to strike, and the court said, take it up on cross-examination, and they didn't. The other important point you need to know is that this is really a case about their failure to conduct a better deposition. This deposition was 17 pages long, it lasted 25 minutes, and they didn't ask him any questions about the records. All they asked him about was his consultation notes. All of those records that they're talking about that were provided to him were available to them at the time of the deposition, and they didn't bother to tell him about it. In fact, in the deposition, he was asked a question, and he said, well, I'd have to have the record to answer that. And that's on page 1061 as well. So if he doesn't have a hospital chart and you're asking him questions and he's making assumptions based on his own notes without a better recollection of what happened, it's really on you if you end up relying strategically on this opinion that he gives you in a 17-page deposition without ever reviewing the full file. Nothing untoward happened here. Mr. Florin had every right as the counsel for the decedent, the counsel for the personal representative of the decedent's estate to talk to this doctor. That's a permissible thing for him to do. He just talked to him And he didn't even ask him questions in cross-examination as to what was the entire nature of the conversation. All he did was establish that he was given additional records. Well, those records were available the entire time. They weren't prejudiced by this, even if it were a change of testimony, because they knew all along that we had a Dr. Fisher that was going to come in and make the very similar statements about what was causing all this. They could not have been prejudiced. In fact, they made a strategic decision that they admitted was a tactical decision to hire a pharmacologist rather than a neurologist who apparently came in and said that morphine didn't cause it. So they had testimony to that effect. Was he a neurologist? No, that was their choice. They could have hired a neurologist. They didn't. And most importantly, Your Honors, the trial judge had the best vantage point of this. The trial judge had the opportunity to look at this situation and acknowledge what the impact of this testimony was. Was it a change of testimony? The trial judge knew what it was. And did it have a prejudicial effect on the appellant? And it's an abuse of discretion standard. If a reasonable judge could make that ruling, that's why the Office Depot case was affirmed. Because in that case, the trial judge found that there was a change of testimony and granted a new trial. And they affirmed it. That's what this court should do here. They should affirm the fact that there was that the trial judge made a decision that there should not be a new trial here. It was an abuse of discretion standard. The Office Depot case, also, the witness was the expert witness, and it was a 180-degree reversal of his prior, I think it was her prior testimony. She said that the negligence did not cause the injury in that case, and then subsequently, after reviewing records, she came back and said, no, it was from the car accident. It was the opposite, that it did cause it. Your Honor, I think basically the counsel is making an argument that they realized that they made a mistake. They should have probably had a neurologist there, and by relying on a witness who was a fact witness, who was a treating physician, based on a deposition that really did not even was not thorough enough to have any opinions. They made a strategic error on their part, and I think that they're sour grapes over it, and I think that this court should recognize that that's something that should be affirmed. I would like to move on to the second argument. I know that counsel's relying on his brief. I just want to point out a couple of things. First of all, the McCall decision clearly says that the caps in wrongful death cases are unconstitutional, and 5 justices agreed to that. The court, when they received the certified question from the 11th Circuit, they rephrased the certified question to limit it to wrongful death cases. They had the opportunity at that time, if they wanted to limit it to multiple claimant cases, they could have done that. They didn't. They made it very clear that the statutory cap on wrongful death non-economic damages violates the right to equal protection under Article 1, Section 2. And the majority in that case, because Justice Periente and Justice Lewis agreed on the vast majority of his analysis, the only thing that she did not agree on, and the reason why she calls it a plurality opinion, is because she didn't focus on, she didn't acknowledge, or she did not agree with his rationale by looking back at what the legislature did many years ago. But they both agreed that under the current state of the law, that there was no rational basis to have this clearly discriminatory
I think they both agreed, if I recall, both agreed that there was no mechanism in the statute for actually passing med-mal insurance savings on to the physicians.
Because the insurance, there was nothing
There was just no mechanism in the statute to ensure that.
Right, so they both agreed also that there were basically two equal protection arguments at issue, and it wasn't just multiple claimants versus one claimant. It was also that the severely injured who are not made whole are treated differently than the less severely injured who are made whole. So if you are somebody like in our case where the person has passed away, you're capped. But if it's a situation where the award was a lot less because of the injuries were a lot less than the cap, then you would be made whole based on what the jury awarded, as opposed to, like in our case, when the cap would come into play. So the less severely injured actually received more than those who are severely injured. And they made that very clear in their argument. I want to read the most important paragraph, I think, from Justice Lewis's opinion. And he says, Section 766.118 has the effect of saving a modest amount for many by imposing devastating costs on a few. Those who are most grievously injured, those who sustain the greatest damage and loss, and multiple claimants for whom judicially determined non-economic damages are subject to division and reduction simply based on the existence of the cap. Under the Equal Protection Clause of the Florida Constitution and guided by our decision in Phillip, we hold that to reduce damages in this fashion is not only arbitrary but irrational, and we conclude that it offends the fundamental notion of equal justice under the law. Pariente agreed with that. She concurred in that language. So we have 5 justices, a majority of the court, finding that's unconstitutional. So can you now go back and tell the court, well, what about single claimants? And if you look at the statute and look at how this statute was written, you can't do that. The Phillip case was looking at the arbitration statute. And the arbitration statute the court found was ambiguous. So the court was allowed to interpret what they meant in that case. So they disregarded the aggregate language and they focused on the individual claimant language. You can't do that in our case. It's very clear. It's crystal clear that the legislature intended this to be an aggregate cap and not just a individual claimant cap. So I think that the case law is extraordinarily clear that this statute is now unconstitutional and it's not enforceable in a wrongful death matter like this. And that's what this is. It's exactly the same scenario. We have a wrongful death case. An estate brought it, and McCall was the same. So I guess if there's any questions, I'd be happy to answer them. We would ask the court to affirm on both grounds. I think that the abuse of discretion standard is very strong. I don't think the court could possibly find that no reasonable judge could rule as the judge did in this case, and the cap is unconstitutional, so we should be entitled to the full amount of our damages. Any questions?
Thank you, Mr.
Thank you.
May it please the court. In my initial brief, I quoted Judge Harris from the Tetrault case. While recognizing that the reasonable exercise of discretion by a trial judge must be upheld, such principle is inapplicable to this case. The primary obligation of any trial court, indeed its most basic responsibility, is to conduct a fair trial. It has no discretion to do otherwise. A ruling by the trial court which denies either party a fair trial cannot be excused based on the proposition that the trial court has exercised its broad discretion. Every point that was made by my opposing counsel has been countered by the case law that was cited in my motion, in my brief. And I'm going to just point out a few of those. In the Office Depot versus Miller case, the expert who was deposed had all of the records at his deposition. He didn't read them. He was then asked to read them again prior to trial by defense counsel. And when he read them again, he changed his opinion. And what was the reason for not contacting opposing counsel? I didn't have to. That's what defense counsel argued in that case, and the court did not accept that argument. Neither should this court. The Office Depot court also talked about whether a party has an opportunity to rebut. And again, I quote, "A party can hardly prepare for an opinion that it doesn't know about, much less one that is a complete reversal of the opinion that has been provided." Counsel, in the brief and in oral argument today, makes a big point. Well, trial counsel didn't do anything. Well, again, what is trial counsel supposed to do when he's hit with a witness who's completely changing his testimony? In light of what occurred, Mr. LaCava, trial counsel, did all he could. But at the end of the day, the jury chose to believe the plaintiff's expert, the treating physician, and closing argument where plaintiff's counsel said 3 times, "I'm required to tip the scales of justice." In closing, I'd like to quote from the Moore versus Gillette case that Judge Wallace wrote the opinion on, and Judge Crenshaw concurred in the opinion, and he said, "Under Binger, the test for exclusion of evidence for nondisclosure during pretrial discovery is whether the opposing party was prejudiced in his preparations for trial. That same principle applies here. It's exactly the same principle. We deserve the fairness for pretrial preparations so that a trial can go forward and the truth can be determined and everyone can be on a level playing field." That didn't happen. All the cases cited to in my brief stand for the proposition that courts should not tolerate tactics such as those taken in this case, and reversal would send a clear message that they will not be tolerated. We are asking this court to reverse and send that strong message. Thank you very much.
Thank you. Thank you all. With that, we are adjourned.